morning, everybody. It's my pleasure to be with this distinguished team. I think we should have a very nice and fruitful discussion on this subject. It has been one of the subjects that witnessed a lot of discussions over the past, I would say, 20, 25 years. Basically, when they asked me to speak about, and sorry, please stop me because I keep talking. So whenever we have 12 minutes, just let me know because otherwise I will take maybe 2 hours of discussion with this subject. It's really a very interesting subject. Right. When they asked me to speak about this subject, I did my PhD in IP law like 15 years ago. And this was one of the most important topics at that time. And I kept working on that area with the Jordanian government and with the Jordanian policymakers. So when they asked me to introduce about this, I thought, what would be the best approach to deal with this? How should we talk about this? So I thought I would give you just a brief of the Jordanian experience in that area with some general introduction of what is the subject. And I'll tell you why I picked Jordan for that. It's not because I am Jordanian, but because it's a nice country to study, because they have something you would see a little bit different from other developing countries. Right. I call this era is the new IP era, because since the introduction of the WTO, we started to see different treatment of IP law and enforcement around the globe. So it's not anymore something that you can afford not to have a strong IP protection. The dilemma is you either have to strong IP protection or not to be part of the world trading system. This is the equation now. If you are not part of this strong IP protection, you are not part of the world trading system. This was the deal. I think there is a lot of discussions about what happened in the Uruguay round and what was the position of developing versus developed countries. This is really a big discussion, and we are not here to discuss it. So I will not talk about it. But maybe you should revert to these discussions. And when we say there is a prevailing issues in IP protection, I think these are the same. The questions have been raised maybe 10, 15 years ago. There are some other emerging issues today, but the prevailing issues will be debatable all the time. So I don't expect to find answers today. In next year, 15, 20 years upcoming, I don't know. But I think these would be discussed as many as the controversy stays. Now, what are these major issues that is being faced between developed and developing countries? The first and important thing is the IP and economic development. Now, economic development, I divided this, or I classified this. This is my personal classification. What we are saying is, how would IP protection affect innovation, technology transfer, attracting foreign investment in various sectors, and the cost or the financial cost associated with the IP administration and enforcement? This is the first big debate. Now, to make it a little bit easier for you, what I found that most of policymakers in developing countries, and I met many of them, would ask you the question of how would intellectual property affect my economic ability as a country? Now, unfortunately, and because developing countries are not as sophisticated as you might see in other developed countries, they don't have the capabilities to basically understand all the issues, or they don't have the capabilities to build their own technologies. They don't have the capabilities to rely on themselves from the economic perspective. So it's very difficult for them. So they start to ask these questions. And they ask a very legitimate question. They are saying, look, businesses in the developed countries benefited from weak intellectual property protections for tens or hundreds of years until they built their capabilities. And today, you don't ask us to have these high standards. So the American market is not like the Indian market, or the British market is not like the market in Nigeria or Cameroon. Definitely it's not. So these debates, and I'm not here basically to solve it, but I'm here to highlight it to you. So these areas would always create that debate. Developing countries would come and tell, no, we don't want to have this strong protection of IP, and developed countries would always push, and especially big and giant companies. On the other side, we need to understand the other argument. Assuming a pharmaceutical company, and I don't know if you know exactly the figures, but for sure, the cost of developing a new drug would be between 700 million to 1 billion US dollars, at least, because they have to examine 14,000 different substances in the human body before they approve that drug. So companies would come and say, okay, we are not charities. We invested billions, we want our return. So the question here would be how to I would say, balance the interests of both developing countries and developed countries, or or their companies. Now, one thing also I wanted to highlight is the cost, or the financial cost. You know how much does it cost to build a proper body to administer IP protection? Do a country like Swaziland, for instance, do they have the capability to build a patent examination system? Absolutely not. There are solutions for that. I was advising the Jordanian government, and we used to use the European Patent Office for that. So you pay certain fees, but you deal with these bodies, or you ask for some technical assistance. It is available. There are solutions, but we don't expect these things to be as easy as you might consider in other developed countries. Also, there are other major issues for developing countries, such as education, such as public health. These areas are affected by IPR, because today I know some students who would just go, they don't buy the book, they go and they just photocopy it. We might consider this as fair use, but the person who's photocopying is not a fair user. Is basically infringing the copyright. How can you now, with the new technologies, even they can just scan these on their phones and then just make their copy? There is a lot of issues related to education, and also the public health is becoming also more and more of complications with IP protection. And we have also the biodiversity, and we have the WTO dispute settlement process. These are really I would say, or I would call them the traditional major issues in IP. And of course, there is some recent trends. I think my colleagues might also talk about these. I don't know, but it's like we have the data exclusivity now. We have the orphan drugs. The orphan drugs is basically when you have just one drug dealing with one of the rare diseases, and how we deal with this, what would be the rules for the patent. These are some of the also emerging issues recently, which is not part of my interest on this presentation. So I'll just I just have this map to show you where Jordan is. Jordan is in the Middle East. It's surrounded by Saudi Arabia, Egypt, Iraq, Syria. We have Israel and the West Bank and the west side. We are close to Europe. We are close to Africa. We are close to Asia. And I'll tell you some facts about Jordan. It has a GDP of US dollars 38 billion. And we have a population of 9.5 million. And the economy of Jordan is a small market. And it has a strategic location, as you saw on the map. There is no big financial and natural resources. We don't have oil like other countries in the region. And the most important capital we have is the human capital. And basically, we have relatively advanced education and public health systems compared also to the region. And we have relatively advanced pharmaceutical and IT industries. And these are industries affected by the IP protection. Now, the question that you might ask yourselves, why Jordan? Jordan is a unique example when it comes to IP protection, because in the 1990s, Jordan has taken an approach to give a strong IP protection, which, in my view, is not suitable for the economy of that country, right? They did this through the accession of the WTO. When they negotiated their accession process to the WTO, there was a lot of debate whether we need that level of IP protection or not. And moreover, Jordan entered into free trade agreements, right, with the United States and with the European Union, and they even introduced TRIPS Plus standards of IP protection. And this is something we need to argue. You know, do we really need that level of IP protection or not? The answer is not easy, by the way, and it's not a black or white, but this is one of the examples that was. And during the 1990s and 2000 something, there was also a lot of studies done by some American bodies, some Jordanian bodies, to examine what would be the effect on that. Personally, I studied this on various sectors, and we had a lot of statistics at that time. There are some positive outcomes that might come from the adoption of higher standards of IP protection. But to what extent, that is the question. I mean, it's not a straightforward process. Protect IP rights today and you will get the benefits tomorrow. No, it's not like that. And in Jordan, we don't have the capabilities for, or like what other countries would have, in terms of utilizing the weak IP protection to copy products, or copy software, or or doing some reverse engineering for medications. I mean, that also benefiting from weak protection is also, you need to know the characteristics of your economy. So the assessment of the Jordanian case, this is basically based on my personal observations and studies. So, I mean, the reference for that is not, I cannot give you 15 or 20 studies to get back to. But what I would say now, the tremendous changes we have seen between the years 1992 and 2005, moving from a basic IP protection into a TRIPS Plus in a matter of 12 years. Would this mean advantages to the economy? Would this benefit us in the future? This question I will answer later. The big debate is always about this, is how do we assess this process? Is it more economic development? It might be a natural natural reflection of other reforms? Is it the advancement of the legal system? Also, this might be a reflection of other changes in the law. To me, assessing the IP policy success or failure is one of the most complicated areas, because we introduced a new strong patent system, but I don't see Novartis or GlaxoSmithKline factories in Jordan. They did not come. This is what policymakers thought. When I interviewed some of them, they thought, oh, okay, once we introduce that law, we will have these companies coming here. I mean, for me, partially this is true, but for the sake of discussion, you need more and more advanced maybe technology, or you need other things to have them together. And one of the big questions is, do you think higher standards of IP protection should not be accompanied by developments in other areas? To me, the question is yes. I cannot protect patents today in a way that could harm my local industry. That is the big question. Today we have 12 pharmaceutical companies in Jordan. They are the best in the Middle East, but they cannot compete with European or American companies. In the Middle East, yes, they are good. But how to utilize this new patent system for them when you, because in the free trade agreement we restricted compulsory licensing. For the government, it's bad news. Cannot now go. I mean, we don't have major diseases in Jordan. I mean, but eventually you restricted your businesses. You restrict your companies. To me, this is a debatable thing where you can measure this on different countries. Policymakers that thought that one of the best things is we change the image about our country. We give the image that we provide stronger IP protection, then we worth people to come here. I mean, come on, guys, we give you good protection. But this is not the case in all cases. Now, also, they thought being part of the World Trade Organization system would mean more business opportunities. And to me, this, if I was a prime minister at that time, I would go for a free trade agreement with the neighboring countries rather than going in a free trade agreement with the United States or with the European Union. For reasons, because I don't have a developed industry that can compete highly in the United States and Europe. The standards here are much higher than in the region there, or maybe in the African markets or the Asian markets. So you need to understand the structure of the global trading before you think that introducing IP would just mean more and more businesses. Sorry, only 2 slides. Now, there are negative aspects when you have a higher standards of IP protection for a country like Jordan. Well, I would say there are tools that were given by these international agreements, and I'm not here to basically to say that you have to play around the rules. No, this is not the aim. But there are always loopholes in the international agreements, or there are areas that were given to support some countries, and it's not advisable that you restrict even these rights. I mean, if you are advising a government or if you are advising a policymaker, we should utilize I would say, mechanisms provided by these organizations. Also, you have to develop your institutional capabilities of IP protection, and this also would mean some financial cost and some technical training. And then what I think should be done for a country like Jordan, always go and renegotiate these terms and conditions. You know, when we entered into a free trade agreement with the US, we had something called the qualified industrial zones. These are areas where you can export to the United States quota-free. Because, you know, in the United States, there is, in textiles, for instance, there is a quota system. So you cannot export exceeding certain amounts. In Jordan, we are exempt from that. But Jordanians, they don't go and work in the textile industry because the wages are low. We have loads of Chinese factories operating in Jordan, and they bring people from China with a very low wage, which Jordanians cannot do. So this does not reflect the need to create more jobs. It's even harming your economy. So sometimes you expect certain benefits, but as I told you, if you don't know the structure of your economy, you will not benefit of that. My final message would be the lessons that I learned personally from the Jordanian experience, and which I would like to convey to you. Five messages. Countries at various levels of development, they need various levels of IP protection. If your economy is not strong, don't have strong IP protection. It will harm your economy. IP protection by itself is not enough to support the business environment or to support innovation. You need to have a comprehensive system that would encourage that. Don't think that a patent system by itself will make you the greatest country in terms of number of inventions or patents every year. The comprehensive system is the solution. Developing countries also must build capabilities in managing and enforcing IP rights, because without that, you will also have a lack of strong element of protecting the rights of your people and of others, because also you still need to support others who come to invest. Now, my advice would be, if developing countries can build cartels or groups when they go and discuss IP protection, they will get more advantages than discussing this individually. Smaller countries would always have smaller negotiation capabilities, and whenever they are in a group, they can get better outcomes. Sorry if I took longer time than expected. This is my vision of how this subject should be discussed, and thank you.
I used to be able to do this without using glasses. My name's Ed Sisson, as I told you, and I'm here more to present an in-the-trench view of the enforcement during U.S. trade shows of the various brands. It's really kind of a follow-on presentation from what we heard from the lady from Doc Martens, and I'm kind of telling you, here's how you kill the small fish before they become the big fish. These are not iconic brands. This is based on about 3 or 4 years of research that my firm has been doing. These are small brands that become industry standards in the industry in which they participate, then they're copied. It comes from our participation in SEMA, which is the Special Equipment Manufacturers Association. It's the largest trade show in the United States. 180,000 people descend on Las Vegas for a 5-day period, and it is the wild, wild west. SEMA is the aftermarket for the high-performance automotive industry. People who have personal disposable income that like to drive fast. That's all it's what it's about. I've discussed many times with the U.S. Chamber of Commerce, and I think our government does a disservice because they tell everybody, go to our government website. You'll learn how to do it. In the end, they got to involve an attorney, as you're going to find out. Okay, so you won't find this on a U.S. government website. And how does this work? So the agenda, well, I'm really going to answer why you do this at a trade show, how the process works, and the timeline, but there's an alternative to the federal government enforcement, and that's at the U.S. state level, and there will be a slide that I highlight, which I think you'll find very interesting. So in the short counterfeit overview, at least this is my perspective, the brand owners are great at promoting their product, but they don't do a very good job of promoting why purchasing a genuine product is worth the price or it's important. And how the counterfeit goods move, it often starts with a trial advert on an e-commerce website, picks up a little traction, but it targets people with no history and no registration. It's really the politics of the schoolyard. In our e-commerce takedowns, counterfeits have been removed 100% of the time when confronted with a registration, usually followed by an apology. Sorry, we didn't know you were registered. Really what they mean is we didn't care until you told us you were registered. But the extent of the problem, we have done this personal research. 1 in 4 U.S. manufacturers at this trade association and also in our local county are counterfeited on Alibaba. That's 1 in 4, yet no one seems to be aware of the problem. Of course, it's different from the problem of what we heard yesterday about the parallel brand, but it's a similar strategy of showing a willingness to enforce before the small fish becomes the big fish. The biggest risk to the brand owner is the distributor exodus. At this point in time, when confronted with the counterfeit, the brand owner is hearing at the trade show, you're losing sales, what are you doing to protect my exclusivity and my distributorship, and what are you going to do about it now? So how can they address this? Well, most products are sold through the third-party networks or distributors, and one distributor represents thousands of sales, not just a one-off that these individuals might find from Amazon. Again, it's not an iconic brand. So when confronted with a counterfeit, we advise them, look, get the story, analyze the product, find out where it came from, make sure it wasn't, a gray market product or something where it was a distributor dumping their excess inventory. Contact your distributors and clearly demonstrate to the distributors your willingness to protect their channel. In other words, protect your channel, protect your distributor. So how do you do this? Well, you can do the e-commerce takedown. It's easy, but it's much like that game as children play with the whack-a-mole. You hit the mole and it pops up someplace else. And then, of course, there's border and customs interdiction. It's expensive, time-consuming. And how do you promote to the distributor that, well, we've kind of got some registrations, we don't know if they're going to work or they're not, but we haven't notified the customs authorities. There's traditional litigation in the United States, very expensive, takes years, and it's glacial. No buzz. What do you promote? Well, we've sued them. And then it takes 4 or 5 months to find out whether or not you're going to get a protective order, and then discovery, on and on and on. But at the trade show, you can resolve it very, very quickly. There's 2 options. You can do internal to the show, or you can do the litigation, both of which show some muscle. So what do we see how blatant this is? The infringing activity can be as much as copying directly the catalog or the catalog page, photos, the same models are being used, manuals, the art is clipped off the website, reproduced from your technical manuals, product photos are the same, and all of those, as you can see, we have somebody said there was a button, yeah. So you can see where kind of categories where it might be. And then, of course, at the trade show, the distributors confront the brand owners, oftentimes in a volatile manner. What are you going to do? And of course, the brand owner is faced with a decision. Options at trade show enforcement. Well, usually what happens, we do the small fish, nothing. Oh, and make no mistake, I've got 2 H's there. It's only just this year. They won't do it next year. Or we'll get them next time. Did you prepare for that? Are you starting to prepare now? We have some clients that are. We don't have our registrations. That's probably the single most common problem that we run into. So you can go internal resolution. You can go complain to the show. The show has hired an outside counsel. They're very agnostic and ecumenical to its members. Now remember, it's this member here against this member here, and the show is deciding whether there's an infringement. I've never met anyone who has been satisfied with what happened at the show. They usually get a slap on the wrist if it's found to be so blatant and egregious, and they're removed on the last day of the show. Okay. Option 2, and this is the unique benefits of enforcing at the trade show, whether you win or lose. You immediately allow the brand owner to demonstrate what he or she is doing to all your distributors at once. The whole industry knows. Sends the deterrent message immediately, increases the brand loyalty to existing customers, it improves the chances of moving new customers to the brand, and it creates an industry awareness that you're not going to be pushed around. In other words, you've won the war whether you lose the court battle. So why at the trade show and not litigate the other alternative? Because a temporary restraining order is only available in this venue. The temporary restraining order requires an immediate need. In other words, if we don't take them down, we will have irreparable damage. And you only need to prove a likelihood of success. You don't have to win that there's infringement, only that there's a likelihood it could happen. Lower evidentiary standards. There's no discovery, less dollars. The opponents are not prepared. You serve them at the show, they don't even have counsel yet. How wonderful is that? It's enforced by uniformed state or federal police that come in, remove the booth and the items. Your unique reasons, you're stopping what is really blatant and egregious counterfeiting by a fellow exhibitor, a member of your group, SEMA. Enforcement is indeed a public display, and the whole industry immediately knows about your efforts. When there's a takedown, it runs through the halls that it's actually happening. So let's go through the mechanics of the trade show litigation. What can be done? On the left, you see trademark registration, patents, copyright, state trademark registrations, and highlight that. This is probably the single most piece of new information you're going to hear. Did you know that in Nevada you can get a registration in 1 hour? 1 hour. In Nevada, California, Louisiana, New York, and Florida, those are the United States exhibition venues. I didn't know until we started researching this a couple of years ago that you could actually, and it's $3,000 in Nevada, you can get a state registration and enforce it in state court. Now you have to own it, you have to meet all the criteria, and even in Florida, but it still takes 3 to 5 business days. So if you know something's happening and you can't have the federal registration complete, maybe it's pending, you can get your trademark registered, or maybe their trademark registered if you happen to be using it, in 1 hour. Now, I would argue that you should get it before 1 hour because it kind of takes away from your credibility at the judge level. So what happens at the trade show and the timeline and the actual nuts and bolts? This is a build slide. I don't know. Can people read that? Yes or no? Can you read it from the back? Okay. Well, you have to decide your enforcement strategy, no biggie. Ensure you own the rights. That's the biggest problem we run into with the small, non-iconic people. And if you don't think this isn't real, we had one person who was litigating a patent suit. Oftentimes, these people do not transfer the ownership into the company, but keep it personally. So who's actually suing, the company or the person? Or, who took that photo? Well, it was my daughter's boyfriend in photography class. Now, they're still together, right? Oh, that split up was real bad. Well, you don't own the rights then, do you? So we spent a lot of time tracking that down so they can enforce. Of course, ensure your rights are registered. Apply for the Nevada trademark as needed. And of course, we have a law firm in Nevada that works with us that prepares all the necessary paperwork way ahead of time, we hope. At the show, again, wild, wild west. You got to gather the evidence. Where are you going to get that? Now, the show will open early. Saturday, I'm using the SEMA show as an example. People are setting up their booths, so you have to have a private investigator there who's kind of watching. Are they putting up the stuff? Are they not? Of course, if you're behind the 8 ball, you apply for your state trademarks. You draft and file the lawsuit, depending upon which court you're going to be in. Service, you have to get that correct. Then you have a hearing, but because you're using local counsel, you're actually, it's all the skids are greased. They know the clerk, they know it's coming. Then of course, you get to hopefully coordinate the enforcement through the show. The show has always told us, hey, you know, we don't like the spectacle of the bursting down the doors. If you let us know, we'll have the police and our federal authorities come in through the back door. And then, you know, evidentiary hearing and trial, usually that doesn't happen because you want them taken down during the show, so you usually drop the suit. And of course, all of the stuff in the gray, at least in Nevada, has to be conducted by a licensed attorney in the state. So what are your results? Well, if you win, you sure hope for that temporary restraining order, preliminary injunction, which is a shut them down. Monetary damages are unlikely, so most clients, why would I want to do that? They ignore the fact that in copyright infringement, statutory damages apply, which means you make the copy, it's per copy, you don't have to prove that you were monetarily damaged as the owner. But you get no preliminary injunction, the middle ground, well, maybe the mark wasn't similar enough, you have to go to trial, have to have evidentiary proceedings, but you've shown your muscle. And of course, then you consider withdrawing the case at the end of the show because the show has gone on. Well, how do you lose? Well, the judge says you're not even close. Well, we can kind of make that judgment and not take it forward. Well, you don't own the marks. That's the biggest one. Somehow you sort of didn't tell us exactly what was going on with the marks, and you find out you didn't own it in order to register it properly anyway. Your registrations weren't valid, probably because you didn't own the marks, and then the case is over. But you've already won. You've shown your muscle, and you're not going to probably get, you know, counterfeited the next time around. So that afterwards, this is where some of our clients fail too. They don't ensure that all their marks are registered. They haven't learned that it's not very expensive to register in all these other countries. They don't monitor their e-commerce, and they certainly don't communicate to their customers the value of buying the genuine products through legitimate channels instead of counterfeits. Everybody here probably gets hawked by marketers, got to increase your traffic, I'm going to do a whole lot of things, but none of them ever say, I'm going to teach you how to demonstrate to your customers or clients why they need to buy from you. I'll bring them to you, but I'm not going to tell you how to sell yourself. And that is a real failure of the brand owners. Get your e-commerce takedowns out there as quick as possible. And then, of course, the trademark registrations. And do notify Customs and Border Protection. And again, the most important thing is publish the positive results. In every example where we have put a PR campaign together with the customer, they have seen their sales increase, they've seen the e-commerce come down, and they've all benefited from it. But it just takes time to get the word out. Because this industry that I deal with is first generation, almost topping over into the second generation. It's not like where I used to be in the rubber industry or tire industry, where it was 100 years old. Very stable, mature. This is new, lots of new ideas. These guys get copied and these women get copied almost immediately. Rolled out at the show, Mandarin comes out and says, oh, I'm going to copy it next week. And we're actually dealing with some people like that now. So I think that's it. Any questions? You can email us later. And I did it in 15 minutes. A little hurried. You're going to get your full time.
Thank you. No. Can you switch? Okay.
Good morning. I'm Philippe Pétillon. I'm a Belgian lawyer, and I'm going to talk about a topic that I was asked to talk about. That is about some recent trends. I also lecture on the second topic. I lecture at the University of Leuven and at the Benelux Trademark Organization, and in a new program as of September at the EU IPO, the Intellectual Property Organization in Alicante. I will talk first about a new trend, definitely new in Europe, which is actually the increasing importance of confidentiality versus intellectual property. So people tend not to file registrations. They tend just to keep information confidential. And as you know, this is actually covered by Article 39 of the TRIPS. And there are 3 conditions there. The first condition is that the information must be kept confidential. It must be valuable, and the right holder must take initiatives to protect that information. In Europe, we have a recent directive that actually is already in force, and which is meant to harmonize the whole system and the enforcement means. The advantages of this approach is actually that the information that you have remains in-house in your company. It's not expensive because you don't pay any registration fees, and it is actually unregistered for unrestricted, for related to subject matter. When you decide not to register and you want to keep that information just confidential, well, it's instant. You have that right away. You don't need to register. There is no formality involved. And it can be perpetual, in infinite, until the end of the world. There is one example that I know of and everybody knows of, and that's of course the Coca-Cola Formula, which, if I understand well, has been there since, 140 years, something like that. And still nobody has ever been able to actually even find it or copy it. They're all nearby copies, I would say. These are a couple of advantages, but what are the disadvantages? It's not exclusive. If another person just obtains rightfully the same information or thinks of exactly the same invention, well, that person will be entitled to keep it confidential as well as being theirs. You will need to enter into quite a number of contracts with people working for you or with contract partners in commercial relationships. You will have more difficulties in enforcing your rights compared to the very specific means that are available for intellectual property right protections. There are also a couple of issues here, and that is that when you focus more and more on confidentiality and on trade secrets, actually you don't really benefit the community. It doesn't really it's not really in the interest of the public, because one of the main ideas behind the patent protection, for example, is that you share information so to allow others, third parties, who are not right holders, to actually make your invention or your method or your product better. And by keeping it for yourself, you don't really participate into that scheme. Also, what is a trade secret? What is confidential? In country A, that may be this. In country B, that may be something completely different. So there are disparities on a national level, of course, on just defining what it is. And there are also disparities on the international level regarding the enforcement. Enforcement means in country A will not be the same as in country B. So these are a couple of issues. Also, we are living in a globalized world. It's more and more technological. There are more and more means that are available, and people tend to call upon outsourcing more and more. So there is an increase of the possibility that there will be a misappropriation of your confidential information. So that was the first topic that I just wanted to touch upon because I was asked to talk about it. What I really want to talk about today is the next one. That's about the conflict that has clearly arisen between privacy and intellectual property enforcement. And I really want to get into a bit more details here. Let me first start with a definition. I need to explain a couple of terms to you. The first is the GDPR, and the other one is the WHOIS. The GDPR, that's the General Data Protection Regulation. It's a European regulation. It is effective right away. There is no implementation involved on the member state level. And it actually is effective since the 25th of last May. What is the aim of the GDPR? the GDPR aims to give physical people, natural persons, more control over the use of their data. The problem is there is a lot of uncertainty about what does that mean, what does that entail, what is more control, and when do you infringe when you actually collect and process information related to natural people. There are huge fines involved when you breach the regulation provisions. There are no guidelines, or there is a lack of useful practical guidelines. The European Commission has promised some, for example, to the internet world, and I will come back to that, but we have still not seen them. So we now have a regulation that is in place, that can be enforced, and we have guidances that were promised, but we don't see them. So it's very hard for people to work in, and of course there is an over-compliance reaction. And what is really gone, although it is expressly provided in the regulation, and you will actually find that provision in quite a number of European regulations and directives, that is the need for a balance, for a balance between the protection of the data of natural persons and other rights. Let me now explain another concept. The other concept is the who is. I don't know, can maybe somebody close the door, or if it's closed, take the next step? Thank you. So the other concept is who is. Who is the information that is related to a domain name on the internet. You know, a domain name that is actually the name that is composed of whatever is at the left side of a dot, and then the extension. Like in .law, you have pétillon.law. That's the domain name. Well, for every single domain name, and there are several millions, there is data. And the data, they are related to the registrant. That's the person who is the right holder of that domain name. And the data, they are composed of the name of the person, an email address so we can contact that person, an address even, and all that information is collected by what we call the registrar. And the registrar is the entity that is registering a domain name with a registry. And the registry is the entity that is controlling the domain names within a specific extension, like in the .com, or like in the .org, or .info, .mil, or even in a country code extension. So I just explained two concepts, the GDPR, and I already raised a couple of problems, and I explained the who is. Why is the who is so important? The who is important because we need that information, definitely as a lawyer. We need it for law enforcement. We need it to protect consumers. We need it for the entire security of the internet, which is controlled by an organization in California, which is called ICANN, the Internet Corporation for Assigned Names and Numbers. And we need it to protect intellectual property. For example, there is an infringement of trademarks, or there is an infringement of copyrights of Hermès in Paris. That entity must be able to go after the person who is actually running the website. And so the ideal way to get after that person is to know who is the holder of the rights related to the domain name. If you don't have that information, you can simply no longer take such action. It's as simple as that. So why is the who is so important for IP protection specifically? Well, we need that information to start investigations as an authority, for example, law enforcement. We also need it as a competitor or as an entity that is a holder of IP rights. It's the ideal way to fight IP infringements. Also, if not only there is a violation of IP rights on a website, but there is also a violation of IP rights in the domain name itself, we must be able to go after that person who is holding it and obtain the transfer or deletion of the domain name. And that's via the unified domain process, the UDRP. If we don't have that information, we no longer can do that. So what's happening now? Well, the organization that has contracts with the registries and with the registrars that I mentioned earlier. That organization is called ICANN in California. It used to have a contract with the registries and the registrars, imposing mandatory the collection of data of the holders of the domain names. And what has ICANN done, because it saw the GDPR coming in its direction, it said, okay, we will change the contracts with the registries and with the registrars. You know, you don't have to collect that anymore, or you don't have to do it in that way anymore. You have to do it in such a way that you're compliant with GDPR. What is the consequence? That at the level of the generic top-level domains, so the generic extensions, not so much at the country code level, but at the generic extensions, there are overreactions. And there are registrars who simply stopped and publicly announced that they would stop collecting information related to anybody, natural persons, companies, European, non-European. It was an ideal way for them to just block all information to data related to the holders of the domain names that actually they control, because they earn money by actually registering the domain names as a registrar. So huge problem, gentlemen and ladies, and there is something to be done here. So what is possible? We can actually take action against the organization itself, which is ICANN. I haven't seen it yet. I have been asked to consider it, and I must admit that I'm still in the phase of considering what we can do. There is also a possibility to take action against the registries and the registrars based on either tort, so it would be an action based on their personal liability, or it could be because they are actually an intermediary contributing to the violation that is committed by the holder of a domain name. So that would be definitely a legal action that we can undertake, and as you know, intellectual property, you think global, but you act local. So you would need to take some action in a local country. Could be in Europe, could actually be elsewhere as well. Definitely elsewhere, since the EU regulation would not apply there. Then what else can we do? We can advocate balance, and that is what I do in the last weeks. I've been representing the International Trademark Association at a presentation with the intellectual property constituency in at INTA in the United States. I'm in contact with the European Commission to explain what the problem is, because apparently there is a lot of information, technical information, that you need to understand the legal impact. And apparently quite a number of officials are not even aware of what we are really talking about. So that's what we are doing. And the second thing is that maybe, but that is more political, and that is of course the long-term action, maybe we can think of turning the who-is system into a system that is comparable to an authority comparable to a trademarks registry. Like the one in Alicante or another one in Benelux or in the United States. So these are two paths that we can walk over with a view to finding back that balance and having a balance between the intellectual property rights and the data protection, the privacy rights. Thank you.
Or do you want me to take the clicker and just do it from here? Good morning, or actually, I guess technically now it's afternoon. My name is Lisa Mueller. I'm a partner at Cashmere Jones. I've been practicing in the pharma biotech area. I'm one of those few attorneys that does both for over 20 years now. My practice is, like many patent attorneys, global, and continuing the diversity of topics of this panel this morning, mine is a pretty broad one in terms of I'm looking at the patentability and enforcement of IP, particularly pharmaceutical inventions in China, India, and the Southeast Asia. So this is a pretty big topic, so I have a lot of details in my slides, and what I'm going to try and do in the interest of time is just summarize a lot of the topics. You'll have the slides made available to you, but I think this will give you a broad kind of overview of some of the unique requirements, not only to pharma inventions, but to inventions in general in these countries, which I think, if we all know, can be particularly challenging both from a prosecution standpoint as well as most certainly an enforcement standpoint. So real briefly, from a pharma aspect, what's patentable in these countries? And I tend to get a lot of questions. Can you patent things like salts and esters and prodrugs, things that have been made popular to patent, particularly in the US and somewhat in Europe? And generally, the answer is yes. There are exceptions, most notably India, which has the famous Section 3D, where basically, unless you have evidence of enhanced therapeutic efficacy, you're not going to be able to get those types of claims through. You see a similar approach in Indonesia as well as the Philippines, but for the most part, in all these other jurisdictions, China, Indonesia, or not Indonesia, Singapore, Thailand, we do see that these types of inventions are patentable. So then moving on to the actual patentability requirements, most of these, or all of these jurisdictions rather, are absolute novelty, not a big surprise. But what a lot of people tend to forget is there are grace periods in these countries, anywhere from 6 to 12 months, depending on whether or not it was the inventor that disclosed the invention, whether or not there was a disclosure of the invention at a trade show. Very specific requirements that you just need to check the local rules on, but sometimes we tend to forget that those grace periods are there. In terms of things like inventive step, generally a lot of these jurisdictions will follow a European problem solution approach, a US approach, or a UK type of approach. In terms of whether or not you can submit additional information or post-filing evidence, generally what we see across the board here is generally that is available to certain degrees, to some extent, as well. Now, in terms of method of treatment type claims, not surprisingly, those tend to be something really US-centric, generally not patentable in any of these jurisdictions, but we do see that in a lot of them, Swiss-type claims are available. However, we do see, particularly in places like India and Vietnam that we'll take a look at in a second, there really is no protection for those types of claims whatsoever, which makes it difficult in those particular jurisdictions. And then you have starting to see a number of jurisdictions allowing the EPC 2000 style claims. Still, some are still trying to decide whether or not that's something they're going to permit or not. Now, with respect to protecting inventions in these jurisdictions, I tend to find, not surprisingly, China and India to be the most difficult. It tends to be difficult to get broad claims out of China. There tends to be issues with sufficiency or written description. Generally goes pretty fast, though. India just tends to be problematic because of the limitations in terms of what you can get that's patentable, the types of claims that you can get as well. Now, if we start to look across to some of the Southeast Asian countries, I think the biggest comment I have here is in most of these countries, prosecution is pretty straightforward. When you get to an inventor step perspective, a lot of these examiners will allow you to conform your claims to claims that you've gotten allowed, let's say in the US or in Europe or in other jurisdictions like China. Also, in terms of sophistication, when you're talking Southeast Asia, the Singapore Patent Office tends to be very, very sophisticated, uses a UK type of approach. And then when you get into Thailand and Vietnam, Thailand, again, generally is going to make you conform your claims to what you've gotten elsewhere. Really, the most problematic aspect for Vietnam is similar to India, where you're not going to be able to get those method of treatment or Swiss-type claims allowed. Now, in terms of timing, how long it takes, and cost, and allowance rates, generally the biggest cost factor we see in these jurisdictions are translations. But I think what a lot of people don't realize is that besides India, there are some Southeast Asian countries where you don't have to file a translation, countries like Malaysia, Philippines, and Singapore. So that actually is helpful with respect to those countries. But you see the costs listed here. They do tend to be somewhat challenging and expensive prosecutions. And they can be, in terms of timelines to grant, really pretty quick, as you see in China here. But they can be long, most notably in India. And then Thailand is really, really long. Tends to be the second most lengthy prosecution next to Brazil, which if any of you prosecute down there, generally anywhere from 10 to 12 to more years in Brazil. But for the most part, what you see is allowance rates that aren't too bad. China's a little low. India really tends to be the most problematic jurisdiction. And then not surprisingly, you start to see in some of the Southeast Asian countries, Singapore, Thailand, Vietnam, for example, you see pretty high allowance rates. So generally, I find I'm able to get my patents through a lot more easily in Southeast Asia than maybe I can, let's say, in China or India, for example. Now, in terms of things like patent term adjustment, patent term extension, generally the patent terms are straightforward. They're 20 years from filing, usually your PCT filing date, since all of these countries are PCT countries. With one notable exception that I do want to mention, because this can be somewhat problematic when you get into doing FTOs in this part of the region. Malaysia has an interesting little quirk in their patent term law that if you have a patent application that was filed prior to August 1st, 2001, the term of the patent is 15 years from grant or 20 years from filing, depending on whether or not that application was still pending as of August 2001. But a couple other little notes. China and India traditionally have been pretty problematic when it comes to things like patent term adjustment, patent term extensions, data exclusivity, patent linkage systems. And one comment I wanted to make about China is there's news coming out of China most recently that some of these protections, like patent term extension, should be coming in the near future. Although with respect to the other 7 countries here, generally we only see patent term extension and adjustment, for that matter, available in Singapore. Otherwise, you're pretty much out of luck in all these countries. Now, in terms of data exclusivity, we do tend to see this across a lot of these countries in this region. Varies anywhere from 5 years to 3 to 5 years, depending on the country. And we also do see some patent linkage, although not as much as you would think. Generally, though, the patent linkage system in these countries tends to be relatively weak. The corresponding agencies to the US FDA, whether it's the China FDA, Indonesian FDA, they tend to require you to list patents that you believe cover, if you're a generic, the product. But they generally don't do any type of sophisticated investigation on that whatsoever. So moving on to another aspect of prosecuting patents in these jurisdictions is divisional practice. And divisional practice here can be pretty complex, particularly when you compare it to divisional practice, let's say, in the US and Europe. There tend to be very strict timelines for when you can file a divisional. And so if you're prosecuting a pharma application and maybe you want to pursue formulation claims, compound claims, depending on the case, you have a lot of different maybe backup molecules you want to file on. You have to be cognizant of the fact that in a lot of these jurisdictions, once that initial parent application issues, you're probably going to be foreclosed from filing further divisionals. So you really need to note the timelines for filing divisionals in these countries. So just by way of example, I'm not going to go through all of these countries in detail, but China is an example of one of these countries that has very sophisticated and somewhat confusing, complex divisional rules. So there's one set of divisional rules that apply when a parent application or a divisional gets allowed, and basically there's a 2-month period for filing a divisional application. If you have a divisional application and that is allowed, if the parent is already allowed, you're not going to be able to file a subsequent divisional. And then when you get into an application that's been finally rejected, there sets a term there for 3 months from filing a divisional, again, depending on the situation with the parent application. So you can see it gets very complex. And in this jurisdiction, we see similar kind of procedures where if the parent application has been granted or allowed, you're going to be foreclosed from any divisionals. I did want to mention Indonesia. They actually have, or actually Malaysia for that matter, they actually have a very interesting system that once the examiner issues an office action, you basically have 3 months to file a divisional. So you can't wait till grant. You actually have to move pretty quickly there. And then in terms of Thailand, another very interesting jurisdiction, there's no voluntary divisionals per se. Once you get a lack of unity rejection, you basically have 120 days to file a divisional. And if you don't get a lack of unity rejection, it's somewhat like Canada, you're pretty much going to be foreclosed from filing a divisional. So some other unique aspects of prosecuting in these areas, particularly India, one requirement that can be particularly challenging are the Rule 8 requirements, Section 8.1 and 8.2. Basically, Section 8.1 says that you're required 6 months from filing and then every 6 months thereafter, providing updates of your counterpart applications that are the same or substantially the same to the application you filed, providing information on continuations, divisionals, oppositions, rejections, so on and so forth. That's generally not too bad of a requirement. The problem is most people just tend to forget to do that every 6 months. You don't get any reminders. Can have a significant consequence if you do that intentionally. Usually pops up in litigation as a potential ground to invalidate a patent. And then the Section 8.2 requirement, that usually comes in the very first office action where you're required to submit copies of office actions, opposition documents, things like that. Again, can be somewhat problematic and burdensome depending on how big your portfolio is. Particularly in pharma cases, there can be quite a lot of documents that you need to submit. And much like the Section 8.1 requirement, it's a ground that can be used to invalidate your patent if your failure to submit is deliberate. A couple other things that are unique about these jurisdictions and foreign filing licenses are not specific to pharma cases at all, but something that does trip a lot of people up. For all these countries here that we're looking at, we see that 5 of them have specific foreign filing requirements, 3 don't. China's are particularly challenging. They basically require every case have a foreign filing license. Basically, if an invention is developed in China, you need to go ahead and get some type of expedited confidentiality review before you file abroad. And that generally can be done in 3 ways. The first way is you submit a description of what your invention is along with a copy of what you're proposing to file, all in Chinese. That method and route of getting a confidentiality review can take a couple months. Alternatively, you can file in China first and then request confidentiality review, and then once you get notification, you can go ahead and file in your other jurisdictions. And that actually can be done pretty quickly as well. And the third route is to actually file a PCT application using the Chinese Patent Office as a receiving office. That can be done in Chinese or English, and you wait till you get your PCT 304 form, and then you're free to go ahead and file. So if you've got Chinese inventors that you're working with, a lot of pharma companies have collaborations with contract research organizations in China. This can be a particularly challenging stumbling block, particularly for U.S. attorneys who like to file a provisional and then a PCT later, and generally wait till the last minute. this can be particularly challenging. India is probably, in my mind, the next challenging jurisdiction when it comes to getting these foreign filing licenses, just because it's a unique system that looks at the residency of the inventor rather than where the invention was made. It is possible to get a foreign filing license in the Indian Patent Office before you file abroad. You can do it pretty quickly. It takes about 21 days. Malaysia and Singapore, about very quick as well. You can request foreign filing licenses there also. Generally takes a couple days, maybe a week. Vietnam is really the only country where no foreign filing license is available. I'm not aware of too many pharma companies that have collaborations with organizations in Vietnam, but something to be aware of, that if you do have Vietnam inventors, you're going to have to file there first, and there's going to be no way you're going to be able to get a foreign filing license to file in Europe or the US. So I'm going to, in the interest of time, skip ahead a little bit to a few more slides, just a couple other comments. I did want to mention a little bit about the Asian Patent Examination Cooperation, also known as ASPEC. This is a regional kind of patent sharing program out in Southeast Asia, where basically the patent offices there have decided to share information, much like the patent prosecution highway that is taken over kind of globally. It's a pretty good system, been around since 2009, works very well, a way to expedite getting grants over in that part of the world. Helps, particularly like in Thailand, where there's a pretty significant backlog. Other unique aspects to prosecuting and enforcing in these areas are the working requirements and compulsory licenses. We don't see too many obligations in this area to work. By far, the one that's most noted is the one in India, where there is a working requirement every year. This working requirement has been the subject of some litigation recently in India. Traditionally, people have begrudgingly complied with the working requirement, but it is getting more traction and something the Indian Patent Office has now been challenged to actually start to enforce. So people were either not complying with the working requirement, hoping the Indian Patent Office just wouldn't notice, not enforce the requirements of working, or they were filing incomplete requirements in their Form 27, which was the form you need to use to comply with the working requirement. But basically what we see across all these jurisdictions is that there are compulsory license requirements. So even if there isn't a working requirement per se, if you don't work your invention, that generally is a ground for a compulsory license. In some jurisdictions, price is an issue that can lead to a compulsory license, and not surprisingly, things like government emergency as well. So turning a little bit to enforcement, in these jurisdictions, enforcement can vary where you need to file your litigation. In some jurisdictions, there are very unique specialized IP courts. China's been in the news recently for its specialized IP courts, as well as Malaysia is known to have a very specialized IP court. Otherwise, you see infringement actions being brought in civil courts or commercial courts. For example, India, there's a whole host of options of where you can go depending on whether or not there's a counterclaim or not. India, you can go from civil court to commercial court to high court, depending. And then in other Southeast Asian countries as well, you see that, again, it varies depending on what jurisdiction you're in. Now, in terms of discovery in these jurisdictions, I think a lot of people are surprised to learn that there are opportunities for some discovery, some broader than in other jurisdictions. China and Indonesia really isn't much discovery available, if at all. But what you do see is that a lot of these jurisdictions have some form of discovery that you can undertake. Keeping on the enforcement track in terms of injunctions, both preliminary and permanent, doctrine of equivalence, liability for contributory or inducing infringement. Generally, as you can see here across the board, there tends to be the availability of preliminary and permanent injunctions with some exceptions, but as you can see, generally they're available. In terms of doctrine of equivalence, surprisingly, that is something that you do tend to see in a lot of these jurisdictions, so you will get some breadth added to your claims beyond just kind of the literal scope. Interestingly, the concepts of contributory and inducing infringement tend to be something that you generally don't see in a whole lot of jurisdictions in this area. Now, in terms of things like parallel imports and the Bowler exemption, you tend to see all these available in these jurisdictions as well. And then in terms of things like type of damages available, generally, not surprisingly, you see compensatory damages, lost profits, some punitive damages depending on the jurisdiction. Damages in most of these countries are calculated from the publication date. In some instances, it might be just the grant date of the patent. Enhanced damages are available also. One aspect to keep in mind in these jurisdictions is some of them have the availability of criminal penalties. As you see, Indonesia has some. There can be in the Philippines for repeat infringers, and then in Thailand as well. So that's something, if you're doing freedom to operate in one of those jurisdictions, you need to be really careful of. Sometimes the criminal penalties are just a fine, but there are a few of these jurisdictions where jail time is a possibility as well. And then, again, if you're doing FTO or you have potential litigation in these jurisdictions, one aspect that always comes up is, okay, I found a patent. I have this happen to me quite a bit in China. What can I do to challenge the validity of those patents, and what are my options? And for the most part in these jurisdictions, you'll see there's availability of a lot of pre- and post-grant oppositions, but not in all of them. But in instances where there aren't pre- or post-grant oppositions, for example, like in China, it's a relatively simple procedure to go in and request at the Patent Reexamination Board that a patent be reexamined. Generally, in China, it is very, very quick. But then in other countries, you actually do have to go to the step to challenge, bring an invalidity action in court. So it just depends on the jurisdiction that you're in. Some as well have opportunities for third-party observations, which can be useful under certain circumstances. They tend to be useful here in Europe, not as useful in the corresponding procedure we have in the US, but it is a mechanism that is available. And so with that, I think I'll stop so we can have a few minutes for questions. There's a lot of information between the three of us, so I think we'll be happy to take any questions.
The gentleman from Jordan. What I have seen in Jordan in 10 years ago already, maybe that has changed, was that it wasn't even possible to educate patent attorneys in the country. And you had to study a full law degree, and then you had to study a full technical degree. And then somehow at some point maybe you could become a patent attorney. And there were a couple of institutional challenges really where it's really hard to bring IP to Jordan. On the other hand side, there's a very strong tie between Jordan and the United States, and IP is part of that tie really. Jordan also has a strong generic manufacturing industry. Again, my state of knowledge is 10 years old now, but that was as I recall it. And apparently there was some indication that this generic industry was not at all negatively affected by the free trade agreements and the reinforcement of the intellectual property. And your talk seemed very honest and very non-sponsored. Would you like to comment a little bit on all of this? That would be interesting.
Yeah, sure. We don't have specialized IP courses in universities. You have to have a law degree which would allow you to basically to work in the legal field. As I explained to you, I think we lacked a comprehensive strategy to deal with the introduction of a new IP laws. As of today, I still sometimes give lectures to IP master students. So it's an extra degree that you take after your law degree. So there is no technical IP studies. But I'll tell you, also, this is a little bit complicated because even in the UK, you will find some of the patent lawyers to study physics or to study sometimes science, or some of them would also develop in the pharmacology, or it's a mixed area. I mean, we haven't reached that stage. Honestly, I think the reason that policymakers maybe thought it's not worth it to have also the cost associated with introducing these new laws. For the pharmaceutical industry, I don't claim to be very close to what they do. I know most of the medications they do are generic, but we have 2 or 3 companies reached a level of R&D that allowed them to do patents according to certain standards. These could be patents. If you take it a little bit further up, it would be just another form of development of medication. So they were arguing that we need a lower standard of protection so that we get these registered as patents and we could protect them. I've met with one of the company directors, and he informed me that he has 17 new patents, according to his understanding. I told him, I don't think, I'm not an expert, by the way, to examine them, but I told him, well, these might be just a little bit of developments of medications. To me, it doesn't seem to be, because there are elements in a patent. It needs to be original, you need to have inventive step. So I told him, no, this to me looks like enhancing the quality of the medication. He said, no, I still argue. So I think we have lack of that technical capability of understanding the issue clearly. And to be honest, I'll tell you, we received a lot of support from the United States in that area. But still we need to do more. I mean, I'm not saying we had that free trade agreement and then they said, okay, go and fight. No, they were helping a lot to develop, as I told, we need to develop administration, understanding, scientific background, because today my colleagues were presenting something. I wanted to give you the background to see where India is coming from, or where Jordan is coming from, and where the EU is coming from now. There is a big gap. We cannot bridge that gap without having a comprehensive strategy how to develop all the related services and education and enforcement. And do you know how much does it cost to train a judge to understand IP or patents? I've seen horrible thinking in neighboring countries in understanding IP. I think the only country that has a strategy, to me, which is very clear, is India in terms of pharmaceuticals. In Jordan, we don't have that one. We're not a big market, so companies, they don't worry about like 9 million. The Indians, they have straightforward process. They don't want to adopt these standards. They want to provide cheap medications. For us in Jordan, I mean, the gaps that you have seen, I think they're still there. Maybe people are not convinced anymore that this will bring them prosperity. This is how I see it. I hope I answered your queries. Thank you.
Is there any more questions? I think.
Not a question, but actually a statement.
I think you can actually call upon the support of WIPO, who would be more than willing to examine how it can assist in further developing education and legislation in your country.
I worked for WIPO. That was one of my client countries.
Voilà, so I'm right.
I think we they supported the master program in IP law. You know, I'll tell you, I worked in 2 IP programs in Jordan, master programs. One of them was purely legal or for lawyers. So you cannot go into that program unless you have a law degree. The other one, I saw some pharmacists and some engineers, and honestly, it was very difficult because the mentality of those who built the program, although it was supported by WIPO, I think also that's one, it was with the German University with Talal Abu Ghazala. I don't know if you are aware of it, because the instructors were always lawyers. So when you teach these pharmacists and try to explain to them something like how to enforce or how to understand the legal background of law, it was very difficult because by nature they just learned to be pharmacists. I mean, there was some effort, and by the way, they closed both master programs now because eventually they found the Jordanian lawyers are all around the region doing IP in Dubai and in Saudi Arabia and in the Gulf, but the market there is so small, so there is no more lawyers wanting to get into that.
Thank you all the speakers. It was a very nice presentation and very valuable information for all of us. Now I would request Mr. Azam Ghani to present the memento to our speakers.
Starting with myself.
Thank you.
Thank you, Azam, and thank you all the speakers. I would also request Mr. Azam Ghani to share the closing notes because we are about to conclude our session.
Right, so good afternoon, everyone. Thank you so much for making this event successful for both the days. And I want to thank especially our sponsors, BSKB again. They made this conference really successful. They helped us a lot. So I want to leave with these 2 invitations, this event. So we have next conference is in San Francisco, Omni Hotels and Resorts. It's on October 22nd and 23rd. So I would request everyone to be, participant of that event as well. Now, second invitation I have is to join the membership. So if you read through this, it says that it has been made complimentary for the cause of intellectual property promotion. So there is no charge at all now on the IIPLA membership. So you can join and ask your colleagues to join the membership as well. Plus, we have committees in it. So we see this Africa committee, all these committees, as per the country and as per the practice. So join these committees as well, and we would have the committee meetings and more participations into it. So with these 2 invitations, I bid adieu to you. And thank you so much for making this successful. And we look forward to see you again. Thank you so much. Have a safe trip back home.